Welcome back. In our spotlight this morning, we're talking about a young woman convicted of killing her mom with a frying pan and a knife, who's hoping the Ohio Supreme Court will agree that she should get a new trial. Court TV brought you the trial of Sidney Powell back in 2023. Powell was convicted of killing her mother, Brenda. She was 16 years old at the time and had been kicked out of college and was keeping it a secret. The attack happened while Sidney's mother, Brenda, was on the phone with school officials at Mount Union University. The defense team argued at trial that Sidney Powell was experiencing a psychotic break at the time that she killed her mother. Well, last year, the defense team got a big win with the Ohio Court of Appeals overturning Powell's conviction and ordering a new trial on the grounds that the judge didn't allow them to present an expert witness to rebut the testimony of the state's expert, Dr. Sylvia Obradovich.
They have testified that Sidney was already broken from reality at this point. When she left Mount Union, she was already starting this psychotic break from reality. Do you agree with that assessment?
I do not agree with that assessment.
Why not?
Because there's no evidence to support that claim other than she said so.
So after the defense won on the appellate level, the Ohio prosecutors took an appeal to the Ohio Supreme Court. So what they want is this conviction to be reinstated. They do not want her to get a new trial. They want it to stand. So the oral arguments are going to happen tomorrow. But this morning, we've got Sidney Powell's attorneys on the show with us. You're going to remember her trial attorney, also friend of Court TV, one of our legal analyst experts, Don Milarczyk. And with him, Sidney's appellate attorney, Dan Eisenbreich, who got that win with the Ohio Appellate Court. Good morning to you both, Dan and Don. Don, I'm going to begin with you. So let's go back to trial and kind of, if you'll set it up for us. So you were wanting to call an expert to refute what the state's experts said about Sidney's mental health, and the judge didn't allow you to?
That's exactly right, Julie. We had our experts watching Dr. Obradovich's testimony, and Dr. Obradovich was saying things on the stand that just were not medically accurate. She was attacking the methodology of our experts. She was saying things for the first time on the stand that she hadn't revealed in her prior reports. So we were excited, we were anxious, we were ready to attack those opinions for the first time on rebuttal. We had our expert ready, willing, and able to rebut everything that Dr. Obradovich had said. We made that request, and unfortunately, the judge denied that request. That was obviously the basis of the appeal, and Dan was successful in getting that conviction overturned, and the Court of Appeals agreed with us that that rebuttal testimony was absolutely essential for the jury to hear in order for Sidney to have a fair trial.
This is really helpful, Don. We've got a clip. This is part of your cross when you were cross-examining the state's expert. Let's take a look at some of what you asked her.
Are you telling the ladies and gentlemen of the jury that that video shows you no evidence that Sidney was suffering from a serious mental disease on March 3rd, 2020?
No, I think that shows us kind of the shock and trauma response after police arrived and she had just murdered her mother.
Okay, now, Don, we may have made an error here because that didn't sound like your voice to me. That was the prosecutor questioning her, wasn't it?
I think it was.
Yeah, but that's okay. I think everybody at home gets the point that it was a great cross. You're masterful at cross. And you had a witness on deck ready to refute all this. The judge tied your hands. So then, Dan, I want to go to you. You were successful taking it to the court above the trial court, who said that this was just wrong. Tell us a little bit about that experience, the arguments that you made, and why the court opined in agreement with you.
Well, sure, and thank you for having me this morning, Julie. It's a pleasure to be back on your program and back among fellow Akron Law alum.
You're an Akron Law alum too? Oh,
absolutely.
My goodness, I didn't know. Oh my gosh. Well,
Class of 14.
Oh,
yeah.
This is the best show that, oh my gosh. Okay, well, we'll talk more off air, but yeah, please, Dan, great to have you as well.
Well, thank you. So we raised 4 assignments of error with the trial at the 9th District Court of Appeals. That is the appellate court. There's an automatic right to appeal from the felony conviction in Ohio to the Court of Appeals. The Court of Appeals agreed with us on the first assignment of error that we raised, and that was the issue that we just discussed, the issue of rebuttal. That the state's expert had testified to new opinions, new matter on the stand, that the defense experts did not have the opportunity or were not on notice that she was going to testify to these things. And we asked for the opportunity to recall an expert to rebut that. The Court of Appeals, in a unanimous decision, found that the trial court erred by not permitting us to call one or more expert witnesses back to the stand to rebut those new opinions, particularly the new opinions as to methodology. Now, what do we mean by that? Methodology is what the defense experts based their opinions on. And a big part of that was they spent some 36 hours with Sydney. They put her through 25 different tests that are widely accepted in the field of psychology to determine things like your mental state at the time of the crime, whether or not the person's malingering or faking their mental illness. And these are all things where the state's expert then gets up and says, well, I didn't put Ms. Powell through any of those tests because those tests wouldn't have told us anything. Those tests are meaningless when it comes to the time of the crime, and all that tells us is the time those tests are being given. And these are things that were brought out in the state's direct examination. These were not previously disclosed in her report. And Don simply asked to recall one or more of his experts to explain why these 25-some tests had evidentiary weight, they had value to the broader issue, and that's whether she met the standard of not guilty by reason of insanity.
Wow, this is really helpful. You know, and this is such a great example, and you both know this, Dan and Dawn, about how we always talk about making your record at trial, why that's so important. Dawn, you did exactly what you needed to do to make that record. And then look what Dan did, took what the arguments you made and the issues that you legally raised and was able to raise it to the higher court who recognized this was wrong. I want to go back to one of the moments in trial, and this is, because what was essential in this case was, central to this case, I mean to say, was whether she was, you know, of the right state of mind at the time of this incident. And here, this is police body camera footage as soon as they arrived at the house to that gruesome scene. And we're only going to hear the audio, and you're just going to see your client, Sydney Powell, listening. Let's take a look.
She's on the ground.
Who is it?
My mom! Someone broke into that window.
All right, hold on.
She's on the ground.
Hold on. Where's your mom? Okay, stay right here.
No, there's so much blood. No, please.
Man.
She's in the window.
Stop. Hold on, we gotta figure out what's going on.
Dawn, when you take a listen back to that, you see her reaction. Remind us, please, your position of where her state of mind was.
It's just absolutely heartbreaking to listen to. And what the jury saw immediately after that body cam video was Sydney on the bottom of the driveway, fallen over, scratching and clawing at the pavement. Her face was bleeding, her hands were bleeding, and she was absolutely in a catatonic state. I mean, she just had a complete break from reality. She had no idea what was happening. She was trying to make sense of her surroundings. And, you know, that psychotic break was traumatic, it was profound, and it was what prevented her from knowing the wrongfulness of her conduct. You have to remember, Sydney didn't try to flee. She didn't try to hide the murder weapon. She didn't try to clean up the scene. She was there when the police arrived, trying to make sense of what had just happened there. So I think that audio, and maybe more importantly, the video right after that incident, absolutely proves that Sydney was having a psychotic break, and that prevented her from knowing the wrongfulness of killing really her best friend, her mother.
Don, I appreciate that. Dan, final word to you. I know you're ready to go tomorrow. We appreciate you making time today to come on here. Tell us what's going to be the main thing you're going to drive home to the justices.
Sure, it's going to be this rebuttal point and just driving home the point that when a state's expert testifies to new opinions on the stand, a criminal defendant has the right to rebut those opinions. I mean, that is what our argument boils down to. And that's why Sidney should get a new trial, as the 9th District agreed in their unanimous decision.
Yeah, well said, Dan. You know, we always talk about, above all else, a defendant's right to a fair trial is always paramount. Thank you both so much for your time. Dan Eisenbright, we'll have to have you back on another case sometime, my fellow Zip. Don Malarsic, we'll get you back soon, as you know as well. Take care, gentlemen. Thanks so much.